Hi everybody. I hope you had a great week. This next 2-3 days I'm going to be doing 3 videos in honor of Memorial Day to celebrate the individuals who gave their lives for this country. Today's video I'm going to try to get more than one section of the Constitution in. It all depends on how long it lasts. I'm trying to try not to go over an hour for these videos, but right now we're going to start with the judicial branch, which Article 3 is what establishes the federal judiciary. Now here's the text of the article. The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. The judges both of the Supreme and inferior court shall hold their offices during good behavior and shall at stated times receive for their services a compensation which shall not be diminished during their continuance in office. Section 1. This establishes the Supreme Court and authorizes Congress to create lower courts. It doesn't specify the number of judges who must sit on the Supreme Court. In previous articles, it only mentions the Chief Justice, when we were talking about impeachment in earlier videos. But since 1869, when the Judiciary Act of 1869 was passed, the number of justices on the Supreme Court has been fixed at 9, 8 associates and 1 chief. Lower courts were created by the Judiciary Act of 1789 and are the courts that are created under this clause. The courts mentioned in Article 1 are known as legislative courts and consist of regulatory agencies such as the United States Tax Court. That's completely different from this. The Judicial Procedures Reform Bill of 1937, which was known as the Court Packing Plan, was an attempt to add more justices to the Supreme Court, proposed by FDR shortly after his re-election in '36. And this bill, although it was aimed generally to overhaul and modernize the entire federal court system, the central provision, and arguably the most controversial, would have granted the president power to appoint an additional justice to the Supreme Court for every sitting justice that was over the age of 70, up to a maximum of 6. Thank God this was defeated. That would have been horrible. So you could see why they called it the Court Packing Plan. The Constitution doesn't say anything when it comes to judges of courts that have been abolished. The Judiciary Act of 1801 increased the number of courts to give Federalist President John Adams the power to appoint a bunch of Federalist judges before Thomas Jefferson took office. And as we discussed before, this was the main reason behind the Marbury versus Madison case in 1803. When Jefferson became president, Congress abolished many of these courts, and it made no provision for the judges of those courts. The Constitution provides that the judges hold their offices during good behavior. This is interpreted to mean that if you're appointed a federal judge, it's a lifetime appointment or until you decide to retire. With the Constitution being as unclear as it was on that, I would say that a lifetime appointment could be assumed with that. Judges also can be removed by impeachment and conviction. The next section. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority, to all cases affecting ambassadors, other public ministers, and consuls, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between 2 or more states, between a state and citizens of another state, between citizens of different states, between citizens of the same state claiming lands under grants of states, and between a state or the citizens thereof and foreign states, citizens, or subjects. In all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as Congress shall make. Trial of all crimes, except in cases of impeachment, shall be by jury, and such trial shall be held in the state where the said crime shall have been committed. But when not committed within any state, the trial shall be at such place or places as the Congress may by law have directed. This section authorizes the federal courts to hear actual cases and controversies only. Their judicial power does not extend to hypotheticals. Generally, a case or controversy will require the presence of adverse parties who have a genuine interest at stake in the case. I mean, it makes sense. I mean, you can't just do a hypothetical, this is, you can't do that with this. And the Constitution is clear on that. One significant thing that has been left out is that although Clause 1 provides that federal judicial powers extend to the laws of the United States, it doesn't provide that it extends to the laws of the individual states. So in turn, the Judiciary Act of 1789 and subsequent acts never granted the Supreme Court power to review decisions of state Supreme Courts on pure issues of state law. And it is for this reason that state Supreme Courts are your absolute final stop regarding common law in each individual state. So that's why that is the way that is. Clause 2 of Section 2 provides that the SCOTUS has original. Now, SCOTUS is SCOTUS, Supreme Court of the United States, and you'll see me use that a lot. The SCOTUS has original jurisdiction in cases that affect diplomats, but also in those issues in which a state is a party, because that is subject to federal judicial power. In other cases, the SCOTUS has appellate jurisdiction, which can be regulated by Congress and has been frequently. But Congress cannot amend the Supreme Court's original jurisdiction, and that's according to the decision in Marbury versus Madison. And that decision held that Congress can neither expand nor restrict original jurisdiction of the Supreme Court. The power of the federal judiciary to review the constitutionality of a statute or treaty, or to review regulations for consistency with a statute or treaty, or the Constitution itself, is what's called an implied power, and they get that from Section 2, Clause 2. Though the Constitution really doesn't straight out provide that the federal judiciary has power of judicial review, many of the founding fathers viewed it as an appropriate power for the federal judiciary to have. For instance, Alexander Hamilton wrote in Federalist 78, quote, "The interpretation of the laws is the proper and peculiar province of the courts. A constitution is, in fact, and must be regarded by the judges as a fundamental law. It therefore belongs to them to ascertain its meaning, as well as the meaning of any particular act proceeding from the legislative body. If there should happen to be an irreconcilable variance between the two, that which has the superior obligation and validity ought, of course, to be preferred. Or, in other words, the Constitution ought to be preferred to the statute, the intention of the people to the intention of their agents." Others disagreed with him, however, saying that each branch could determine for itself what was constitutional and what wasn't of their actions. Wrong. But Hamilton goes on to kind of counterbalance this a little bit. There were of these judicial supremacist people, those that demanded that Congress and the president are compelled by the Constitution to enforce all court decisions, including those that are in their eyes, or those of the people, violated American principles. And I'm quoting Hamilton again. Nor does this conclusion by any means suppose a superiority of the judicial to legislative power. It only supposes that the power of the people is superior to both, and that where the will of the legislature, declared in its statutes, stands in opposition to that of the people, declared in the Constitution, the judges ought to be governed by the latter rather than the former. They ought to regulate their decisions by the fundamental laws rather than those which are not fundamental. And Hamilton goes on to condemn legislation from the bench. I mean, you've heard in recent years a lot of people complaining about judges legislating from the bench, and it does happen. It happens frequently. But I recommend you all look up Marbury versus Madison and read about it. Wikipedia has an awesome article on it. It's a very important case, and I highly recommend you guys check it out. And Clause 3 provides that federal crimes, except in impeachment cases, must be tried before a jury. And a trial must be held in the state where the crime was committed. And we know that because we see it frequently when we talk about big cases. All right, in the next section, treason against the United States shall consist only in levying war against them or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of two witnesses to the same overt act or on confession in open court. The Congress shall have the power to declare the punishment of treason, but no attainder of treason shall work corruption of blood or forfeiture except during the life of the person attainted. And just basically, this section specifically defines what is considered treason in the United States. And it's derived from, and also in contrast to, English law, where crimes including conspiring to murder the king or violate the queen, in other words, rape the queen, were punishable as treason. In 1807, the SCOTUS ruled that there must be an actual assembling of men for the treasonable purpose to constitute a levying of war. So it really explained what would be levying war against the United States. And the corruption of blood part, a lot of you aren't sure what that means. Basically, if someone is convicted of treason, their descendants were not tainted as it would be. I know some of you are Game of Thrones fans, and I'm sure you know that Ned Stark was executed for treason, and they kept giving Sansa hell in that because she was Stark's daughter. That's what's called corruption of blood. Just because you are kin to the person convicted of treason doesn't mean that you are automatically a traitor. That's not how it works here in the United States. And Congress is also allowed to confiscate the property of traitors, but it must be given back to the heirs of the traitor upon his death. And that, my friends, ends Article 3, and I think we're going to have enough time to add some more in here. So let's start with Article 4, which outlines the relationship between the states as well as the relationship between the states and the federal government. The first part, full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state, and the Congress may by general laws prescribe the manner in which such acts, records, and proceedings shall be proved, and the effect thereof. And basically this clause requires each state to respect each other, for a lack of a better term. In 1813, the SCOTUS ruled that the merits of a case, as settled by courts of one state, must be recognized in the courts of all other states. Also, state courts cannot reopen cases which have been conclusively decided on by the courts of another state. You can't do it. The next section, the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. Kind of ambiguous here. This has resulted in a number of different interpretations, and it's kind of confusing. It can be. But none of the interpretations that have been used over the years has been endorsed by the Supreme Court. SCOTUS has long held strong in the fact that this clause simply means that one state can't discriminate against the citizens of another state in favor of its own citizens, and that appears to be the dividing line there, and that's what that clause has been interpreted to mean by the Supreme Court. The next section, a person charged in any state with treason, felony, or other crime who shall flee from justice and be found in another state shall, on demand of the executive authority of the state from which he fled, be delivered up to be removed to the state having jurisdiction of the crime. Pretty self-explanatory. If you commit a crime in one state and you run to another state, when you're found, you have to be extradited to the state where you committed the crime upon request of the state's governor. Pretty easy. And, you know, that happens. I mean, we see a lot of it going on. People will commit a crime and then haul buggy to another state, and then they find him. And what we don't see is the governor requesting that the criminal be delivered back. That's just, you know, that just happens in the background. The next section, no person held to service or labor in one state under the laws thereof, escaping into another, shall, in consequence of any law or regulation therein, be discharged from such service or labor, but shall be delivered up on claim of the party to whom such service or labor is due. This is the Fugitive Slave Clause that was originally put in the Constitution. It was introduced by Pierce Butler and Charles Pinckney, and it was objected to by James Wilson, saying that it would require state governments to enforce slavery at taxpayers' expenses. It was withdrawn but slipped back in, and it passed anyway. But what it didn't do was provide means of enforcement. It came with the Fugitive Slave Act of 1793, and as we all know, this section of the Constitution is now null and void since slavery has been abolished. The next section, new states may be admitted by the Congress into this union, but no new state shall be formed or erected within the jurisdiction of any other state, nor any state be formed by the junction of two or more states or parts of states without the consent of the legislatures of the states concerned as well as of the Congress. Okay, Congress is granted the authority to admit new states into the union, but you can't create new states from parts of other states without the consent of the states involved. This was as a result of Virginia and North Carolina, who claimed lands as far west as the Mississippi River. Basically, back in the time that the Constitution was written, Virginia included what we know now as Virginia, West Virginia, and all of Kentucky. And North Carolina was North Carolina and Tennessee. And those two states had the option to say no to the creation of Tennessee and Kentucky. However, they did not, and we now have those two states. Kentucky admitted in 1792 and Tennessee in 1796. An important part, though, this clause was ignored by Abraham Lincoln in 1863 when West Virginia was created. when the War for Southern Independence started, Virginia had seceded from the Union, but it was a divided state. The mountainous counties, which we know now as West Virginia, they didn't want to leave the Union. They formed a government of the state of Virginia, which was recognized by the Union, and it was loyal to the Union, while the legitimate government of Virginia was leading the Confederacy. 2 years later, while the war was still going on, Lincoln simply signed an executive order creating the state of West Virginia, in direct violation of this clause. Another example of Abraham Lincoln's contempt for the Constitution. Just because we're at war does not give you the right to suspend the provisions of the Constitution because you want to. And I can go into more detail on how every president has subverted the Constitution. Regarding secession, the Constitution doesn't say anything about it. Texas versus White in 1869 resulted in a Supreme Court decision holding that a state can't unilaterally leave the Union. But this is a violation of rights granted to the states under the 10th Amendment, which we'll discuss in further detail later on. The next section. The Congress shall have the power to dispose of and make all needful rules and regulations respecting the territory or property belonging to the United States, and nothing in this Constitution shall be so construed as to prejudice any claims of the United States or of any particular state. This clause grants Congress management authority of territories or other properties owned by the United States. Also, nothing in the Constitution can be interpreted to harm any claim of the United States or any state, any individual state. The exact to what extent the powers of this clause range has been a matter of debate for quite a while. The federal government owns about 28% of the land in the United States. This includes military bases, national parks, Native American reservations, etc. You can find federal property in every state in the Union, but most of it is in the western part. As a matter of fact, over 80% of the state of Nevada is owned by the federal government. That's nuts. That's out of control, and there needs to be some constraints put on it. The next section, which is really more of a sentence, the United States shall guarantee to every state in this union a republican form of government. Here, the Constitution mandates that all U.S. states must be republics. They must be grounded on the principle of government getting their powers through the consent of the governed. However, the Constitution really doesn't go into any detail about what exactly constitutes a republican form of government. The Federalist Papers, which I recommend you all read, I really recommend you read the Federalist Papers because it gives you great insight. And the Federalist Papers give great insight as to what the intent of the Founding Fathers were when they mentioned republican form of government. A republic is distinguished from a direct democracy, in which the Founding Fathers had no intention of getting into. Madison wrote in Federalist Number 10, hence it is such that democracies, it is that such democracies have ever been spectacles of turbulence and contention, have ever been found incompatible with personal security or the rights of property, and have in general been as short in their lives as they have been violent in their deaths. So you see how the man who wrote the majority of the Constitution felt about a democracy. So whenever you see somebody on TV who holds federal office say, our democracy, kindly remind that blithering idiot that we're not a democracy, we're a federal republic. We have democratically conducted elections, but we are not a democracy. We are a republic. And the next section, and shall protect each of them against invasion and on application of the legislature of the executive when the legislature cannot be convened against domestic violence. This part simply requires the United States to protect each state from invasion and domestic violence. This provision was invoked in 1914 by President Woodrow Wilson during the Colorado coal strike. And that concludes Article 4, and I think we'll have time to go through Article 5. This is going to be a very in-depth video, and I'm liking this. Let's see. Article 5 discusses amending the Constitution. Now, this is a very important part of the Constitution. I need you all to pay close attention to this. Article 5 is our saving grace in these turbulent times that we're going through right now. So please, please listen. The first section, the Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or on the application of the legislatures of 2/3 of the several states, shall call a convention for proposing amendments, which in either case shall be valid to all intents and purposes as part of this Constitution when ratified by the legislatures of 3/4 of the several states, or by conventions in 3/4 thereof, as the one or the other mode of ratification may be proposed by the Congress, provided that no amendment which may be made prior to the year 1808 shall in any manner affect the first and fourth clauses in the 9th section of the first article, and that no state without its consent shall be deprived of its equal suffrage in the Senate. Okay, I know that was a mouthful, so let me get to it. 33 amendments have been proposed to the United States Constitution and approved by Congress and sent to the states for ratification. Of those 33, 27 have been ratified and are now part of the Constitution. 6 amendments have yet to receive the required number of states to approve them. They are not part of the Constitution and are in no way binding until they reach that threshold. 4 of these amendments, 4 of the 6, are still technically open and pending. 1 is closed and has failed by its own terms, and 1 is closed and has failed by the terms of the resolution that proposed it. This article gives you 2 methods for amending the Constitution. The first method is when a prospective amendment passes 2/3 of both houses of Congress. Then it must be sent to the states for ratification. Congress can choose either ratification by state legislatures or ratification by convention in each state. But in order to become part of the Constitution, it has to be approved by 3/4 of the states, which is currently 38. The second method is when 2/3 of the states, which would be 34, petition Congress for a constitutional convention. Then Congress must set a date, time, and place for this convention to take place. The states then send delegates to this convention. The delegates write amendments to the Constitution. Once these amendments come from the convention, they are immediately sent to the states for ratification, for 38 states to approve them. It bypasses Congress. It bypasses the President. It bypasses the Supreme Court. That's the important part. The people can amend the Constitution, and it is court-proof, Congress-proof, and President-proof. They can't touch it. And that's what we need to do. We need to get our state legislature to pass a petition for a constitutional convention. There's 18 states now, I think, that have passed it. So we're halfway there. We're halfway there. We need more. We need more because we need to have a constitutional convention. At this convention, we can limit Congress's terms. We can stop the federal overreach that the government is doing by amending the Constitution and telling them what they can and can't do. And the reason is because it comes from us, the people. Congress forgets that we have the power. Either that or they know we have the power. That's why they've intentionally dumbed us down to make us think that we don't have power, but we have the power. And the fact that they gave us two methods to amend the Constitution is another form of compromise from the original Constitutional Convention in 1787. There was a dispute going on between two groups, one of which believed that the legislature, the Congress, should have no role at all in amending the Constitution. James Madison, the man, he addressed this subject in Federalist 43. It guards equally against that extreme facility which would render the Constitution too mutable, and that extreme difficulty which might perpetuate its discovered faults. It moreover equally enables the general and the state governments to originate the amendment of errors, as they may be pointed out by the experience on one side or the other. So, you want to talk about the Founding Fathers being geniuses? Jefferson was a genius. Frickin' James Madison was right there with him. Each time the amendment process has been used, every one of the amendments that has come out has come from Congress. Congress has proposed it, voted on it, passed it, and sent it to the states. The convention option, where the states hold a constitutional convention, is a tool in which Alexander Hamilton argued would enable state legislatures to put up too many barriers, in his view, against encroachment of the national authority. But I don't think Hamilton was able to really realize how much federal overreach would have occurred and would still be occurring. If he did, he would not be arguing against it. So far, the convention option has not been used. I think it should be. I think we should wake these guys in D.C. up seriously. But, let's see. Under the convention option, I think I've already discussed this, but I'll run over it again. Because I'm going by my notes here. I may get something. I may speak on something and forget about it. Under the convention option, once you have 34 states that have called for a convention, Congress has to name a time, place, and date. Yeah, I did go over that. Okay. But there's a big difference. With Congress proposing the amendments, it's subject to judicial review, just like other laws and resolutions. And like I said before, with the convention option, the amendments come from the people who hold the ultimate power in this country, and therefore the amendments that come out of the convention are immune to judicial review. Another important difference is once approved by the Congress, amendments proposed do not require presidential signature. The president has no function in the amendment process at all. And this was affirmed by the SCOTUS in Hollingsworth versus Virginia in 1789. And like I said before, Congress has the option to choose whether ratification is done by state legislatures or conventions in each of the states. There have been a few cases where Congress chose conventions, and this is the process on how everything takes place. The archivist of the United States, the person who runs the federal archives, is charged with the responsibility of administrating this ratification process. And what will happen is the archivist officially notifies the states by a registered letter to each state's governor that an amendment has been proposed, and sends a copy of the amendment with the registered letter. Each governor will then formally submit the amendment to their state's legislature or ratifying convention, whichever one is chosen. And then the process goes into ratification. Once a state has ratified an amendment, it sends the archivist an original or certified copy of the state's action. And upon the receiving of the 38th state's ratification notification, it is the duty of the archivist to issue a certificate proclaiming the particular amendment duly ratified and part of the Constitution. The new amendment and its certificate of ratification are then published in the Federal Register and the United States statutes at large, and that serves as official notice to Congress and the country that the ratification process has been successfully completed. The Constitution doesn't say anything about the issue of whether or not Congress can set time limits on ratification of amendments, and it also says nothing about issuing a ratification deadline, which has been done quite a bit. Matter of fact, the practice of limiting the time available to the states to ratify the proposed amendment began in 1917 with the 18th Amendment. All amendments proposed since then have included a deadline except for the 19th Amendment and the still pending Child Labor Amendment, which has yet to be passed. And so that's the amendment process, and that completes Article 5. And it looks like we may be able to get into Article 6. So I think I'm going to do Article 6 and Article 7 and then stop it there, and then we will start on the amendments in the next video, because Article 6 and Article 7 are rather short. Article 6 establishes the supremacy of the federal government among other issues that we'll discuss. But first, here's the text of the article. All debts contracted and engagements entered into before the adoption of this Constitution shall be as valid against the United States under this Constitution as under the Confederation. This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby, and anything in the Constitution or laws of any state to the contrary notwithstanding. The senators and representatives before mentioned, and the members of the several state legislatures, and all executive and judicial officers both of the United States and of the several states shall be bound by oath or affirmation to support this Constitution, but no religious test shall ever be required as a qualification to any office of public trust under the United States. The first clause basically says that all debts that the United States had under the Articles of Confederation would be just as valid under the Constitution, which means they would honor their previous debts. That the adoption of this new form of government did not erase any of the debts that they accrued while under the Articles of Confederation. Pretty easy. It's basically keeping your word. Clause 2 provides that the Constitution, all federal laws made following this, and all treaties made under the authority of the Constitution will constitute the supreme law of the land. And it provides that state courts are bound by this supreme law, and in case of conflict between federal and state law, federal law overrules. Even state constitutions are subordinate to federal law. So there's that. And the third clause, federal and state legislators, executive officers, and judges are all bound by oath or affirmation to support the Constitution, and Congress can determine the form of such an oath. Congress also cannot require a religious test for any federal office. Congress usually includes the customary words, "So help me God," in an oath, but no individual is under any requirement or compulsion to say those words. For instance, if someone is an atheist, and they've won election to a federal office, or they've been appointed to a federal office, they're not required to say the words "So help me God," because if you're an atheist, you don't believe in a God. So, because if they were to require it, that would constitute a religious test, just like you can't pass a law saying that someone who is Muslim or Jewish or Buddhist can't hold a federal office. You can't do it. I mean, I know that a lot of people have issues with Muslims nowadays, and one can't blame them. But you can't say that they can't hold federal office, because that's violating the Constitution. You can't have a religious test. So now we go to Article 7, which is a little bit more, it's the shortest article there, but I'm going to go into a little bit more detail about it, just to fill up this hour. I got about 20 minutes left. So let's go with the text first. The ratification of the conventions of 9 states shall be sufficient for the establishment of this Constitution between the states so ratifying the same. That's it. That's all for Article 7. So we're going to go into some background detail. The convention concluded on September 17th, 1787. On September the 20th, the drafted Constitution was submitted to the Congress of Confederation for its endorsement. It took 8 days of debate, and the opposing sides came to the first of many compromises that pretty much would define the ratification process. The Congress of the Confederation voted to release the Constitution to the states for the consideration, but neither endorsed nor opposed ratification. And that was done to show neutrality, because if the Constitution were approved, it would mean the death of the Confederation. So, ratification went as follows. Delaware was first on December 7th, 1787, with a unanimous vote of 30. No people opposed it. Pennsylvania was second on December 12th, 1787, with 67% of the vote. New Jersey was third on December 18th, 1787, with a unanimous vote. Georgia was fourth on January 2nd, 1788, with a unanimous vote as well. Connecticut was fifth on January 9th, 1788, with a 76% vote. Massachusetts was sixth on February the 6th, 1788, with a 53% vote. A very close vote. It was 187 yeas to 168 nays. Maryland was seventh on the 28th of April, 1788, with an 85% vote. South Carolina was eighth on the 23rd of May, 1788, with a 67% vote. New Hampshire was the ninth state, very important, on June 21st, 1788, with a 55% vote, 57 yes, 47 no. Virginia was 10th on June 25th, 1788, with a 53% vote, 89 yes to 79 no. New York was 11th on the 26th of July, 1788, with also a 53% vote, 30 yes, 27 no. And at that point, the Constitution had already been started to put into effect, but I'll get into that here in a little bit. North Carolina was 12th on November 21st, 1789, with a 72% vote. And the closest vote of all was Rhode Island on May 29th, 1790. 34 yes, 32 no, a 52% vote. That was close. In those years following the convention, a lot of debate took place throughout the country over the Constitution that had been proposed. Supporters began the ratification process in the states where they had little to no opposition, leaving for later on the ones who were going to be a little bit more difficult. On the 21st of July, 1788, when New Hampshire became the 9th state to ratify the Constitution, this established it as now the official framework for the United States. And although it was officially enacted, you still had New York, Virginia, Rhode Island, and North Carolina who had yet to approve it. The Congress of the Confederation chose March 4th, 1789 as the day for commencing proceedings under the Constitution, quote. Virginia and New York would ratify the Constitution before the new Congress assembled and was able to send their representatives to the new Congress. So, when Congress assembled for the first time, we had 11 states. North Carolina and Rhode Island were considered brother states, but they were foreign states at the time. Georgia and South Carolina were separated by North Carolina from the rest of the country. So, after 12 amendments were sent to the states in June of 1789, North Carolina then ratified the Constitution, and Rhode Island, smallest state in the Union and one of the biggest pains in the rear at some times, it rejected the Constitution in March of 1788 in a referendum. But they called a ratifying convention of 1790. Rhode Island was about to be considered a foreign government. They were faced with that threat, and I don't think Rhode Island would have lasted by itself, as small as it was, and with the lack of some of the things that the rest of the states together would have had. And as I said before, it was the narrowest of margins that approved the Constitution. And we'll go into this. I debated on whether or not to discuss this, but I think I should. Secessionists have used Article 7 to argue that the states have a right to secede from the Union by revoking their ratification of the Constitution. Several states declared in their ratification resolutions that the people can resume the powers granted to the United States whenever the government is perverted, quote, perverted to their injury or oppression. New York actually originally included a provision in their ratification resolution stating that the right to withdraw from the Union, they have the right to withdraw from the Union just as easily as they entered into it. Objections from Alexander Hamilton and John Jay resulted in that particular language being excluded from the resolution. But several of the states who seceded from the Union, the 4 states that were original 13, Virginia, North Carolina, South Carolina, and Georgia, included in their secession ordinances the revocation of their ratification of the Constitution, because they felt that the government had been, in those words, perverted to their injury or oppression. And a lot of evidence supports that case. But that is the end of the original text of the Constitution. We're going to start on the Bill of Rights in the next video. I hope you guys have enjoyed this, and please feel free to debate. Feel free to ask me questions. I will answer them as to the best of my ability, and if I don't know the answer, I will damn sure look it up. I don't claim to know everything, although I do know a lot about a lot, but I really do hope you guys are enjoying these, and until next time, peace.